pass it over to Brian. Brian is a Senior Assistant Attorney General in the Colorado Attorney General's Office. Brian is counsel to the Colorado Department of Public Health and Environment, including the Medical Marijuana Registry and the Division of Environmental Health and Sustainability, which oversees industrial hemp products. Thank you, Brian, for coming, and I'll pass it on to you.
Great. Yeah, thanks for having me. I appreciate it. I'm always happy to talk to this group. And, in the past, I've always been just really impressed by the questions that you've had. So, I'll do my best to kind of get through what I have. I asked for some questions in advance. I was able to get some of those and hopefully address some of those. So up front, just so you know, I specialize in medical marijuana and hemp issues. It seemed to me there was a significant interest in sort of employment questions that intersect with epilepsy. That is out of my area of expertise. I have tried to look into those questions and provide some answers, but on those questions, I think we'll get there, but I think there are employment attorneys who would probably be a better resource for you on those questions. But as I said, I've tried to give you some answers just on my sort of educated layman's research. So we'll hop right in. Let me make sure that this works here. Did that flip slides for you?
Yes, it did.
Okay. Yeah, so as it says, I'm here in my personal capacity, so don't hold it against my boss if I say something incorrect. Overview, we'll talk briefly about federal and state law and being inconsistent, why that is. Colorado as a case study, some differences between medical and recreational, patient and physician requirements, federal law, the Controlled Substances Act and its enforcement, indirect consequences of federal illegality, and some farm bill stuff, which is mostly hemp and CBD. So federalism, basically means we have state and national governments that we live under, and you can see each has their own sphere, but in the middle there is punish criminals and regulate interstate commerce. So marijuana kind of falls into that shared power, which means that the federal government and state government can both criminalize certain conduct, including the use of marijuana, or not. And states have in recent years decided that they're not going to criminalize marijuana to various degrees. And as you see in this map here, almost all have decided to move away from total prohibition. Some, including Colorado, have gone to the highest level of permissiveness, allowing medical and recreational use, of course, subject to requirements. And some have kind of taken minimal steps, including Wyoming, which allows CBD and low THC, but that's about it. So Colorado, this came about in 2000 with an amendment to the Constitution, which authorized medical use of marijuana for debilitating medical conditions, which includes epilepsy. It's offered a limited criminal protection and did not legalize the sale of medical marijuana. That kind of gap was filled 10 years later with the Medical Marijuana Code, which authorized new suppliers of medical marijuana, including stores, but gave localities a choice. So, and it imposed new physician regulations. So just briefly on localities, they have the choice of whether or not they're going to allow stores to sell medical marijuana or recreational marijuana, or kind of make the choice between the two. So for a while, Colorado Springs, for example, there were medical marijuana stores, not recreational marijuana stores. So if you wanted to get recreational marijuana there, you'd have to go somewhere else and bring it back. Medical versus recreational, and some specifics of medical marijuana. People kind of ask, why do we still talk about medical marijuana in a state that's legalized recreational? Some of the key differences are on the quantity side. You get more on the medical marijuana side, potentially. There's an avenue for that, whereas recreational, the quantities are more limited. Price is lower usually because of tax, and the availability is more so. As I said, some localities do allow medical marijuana stores while not recreational, so availability is more medical there, as well as primary caregivers. They tend to be a medical marijuana source as opposed to recreational. The physician role, they provide a recommendation for a patient. This is the substance of it is that this patient has a qualifying condition, including epilepsy, for example, and might benefit from the use of medical marijuana to address that condition. They have to have a bona fide physician-patient relationship, which means they have to have a valid license and good standing. a treatment or counseling relationship, and do a full assessment of medical history and current condition, and appropriate personal physical examination as well. Minor patients are slightly different. The key thing there is you typically need 2 physicians to weigh in. And in recent years, they've sort of expanded what is considered a physician under this. And so now, you can be not only a physician, you can be someone with prescribing authority. A dentist, for example, could do that. Physician oversight, they do have professional oversight by the Colorado Medical Board, or if it was a dentist or a prescribing nurse, their respective boards. There's standards there, medical marijuana specific guidance for them. My client at the Department of Public Health also oversees physician roles and other recommending roles, and primarily about whether or not they have an improper financial relationship with the center. Criminal law, they potential there. I'm happy to jump into that if people are interested. Other crimes possible as well. Some selected restrictions, otherwise caregiver and patient cultivation restrictions. Now Colorado has basically put restrictions on where and how much people can cultivate. So part of this involves registration of the Department of Revenue with the location of the grow, the patient card numbers for the patients being grown for, and the plant count. Residential property limits, how much you can grow, depends kind of on the property you're growing. Other restrictions, you can't be doing it in a way that endangers the health and well-being of other people, not in plain view, not when it would constitute negligent behavior, professional malpractice, or use on school grounds. Now, this one has been changing every year, seemingly. So now the use on school grounds is something that is permitted to a certain degree, although it is can be school by school. If you have questions about that, I would suggest talking to the local school regulating entity, the principal, to see what their policy is on that. There are also local government restrictions that can come into play. So local governments can enact ordinances to address public safety. So they can, regulate the types of residences where grows happen, plants per residence, permissible lights, odor controls, building and nuisance and abatement issues, and also supplier restrictions. So we talked about earlier, localities can choose whether or not to allow stores of a specific type. So turning to federal law, kind of why do we care? We'll cover that. Controlled Substances Act, enforcement discretion, Department of Justice, prosecutorial discretion, Congress imposed limits on enforcement, and the indirect consequences of federal illegality and hemp and CBD issues. Gonzalez v. Raich, this was a U.S. Supreme Court case where we had 2 people in California. They were residents using medical marijuana under California law that allowed it. The DEA seized and destroyed their plants. They sued the DEA, basically saying it's legal under California law, so can the federal government prohibit use of marijuana that is in compliance with California law? And the answer is yes, notwithstanding that California legalized it. The federal government can enforce federal criminal law against marijuana use that is otherwise lawful under state law. So that just basically means they can enforce it even in Colorado or Wyoming. They can come in and enforce that law, even if you're in compliance with Colorado law. As we'll get to, that very rarely happens. But the Controlled Substances Act regulates manufacturing, distribution, and possession of controlled substances, which are scheduled based upon abuse, potential, and effects. Schedule 1 is the highest, most restrictive, and includes marijuana, and which effectively criminalizes the manufacturing, distribution, and possession of marijuana under federal law. So these prohibitions can be enforced against those who are using marijuana lawfully under state law. But the Controlled Substances Act isn't just about things you can't do. It also allows providers like physicians to administer, research, manufacture, or dispense controlled substances. So that registration has to be done consistent with the public interest, with controls against unlawful diversion. Conner v. Walters was a Ninth Circuit case that provided some protection to physicians. It basically said they're allowed to provide a recommendation for medical marijuana, and that's a protected speech under the First Amendment. Massachusetts physicians in 2014 kind of found there's a limit to this protection. This doesn't allow physicians to own or be financially involved in medical marijuana centers. So the court there kind of said, well, that's going beyond just having a conversation, which would be a protected First Amendment issue. If you're actually running a business where you're distributing marijuana, that's beyond the protection of Conner v. Walters. And Colorado physicians, same sort of deal where they were violating some other laws as well. And so the DEA revoked their registration. So the enforcement of the Controlled Substances Act, the reality is federal government has discretion and limited resources to enforce the Controlled Substances Act. And so there were these Department of Justice memos kind of outline how the department is going to, or how the federal government is going to go about enforcing. Then the Rohrabacher-Blumenauer Amendment. So the DOJ memos are kind of have been rescinded, so they were in place for a while. They're less important now. The Rohrabacher-Blumenauer Amendment is what's called an appropriations rider, which basically is Congress telling the executive branch, including the DEA, you don't have any money to enforce the Controlled Substances Act against states that are implementing medical marijuana laws. So it's sort of a functional immunity. It doesn't change that like medical marijuana use is illegal, but it just prevents the DEA from prosecuting those cases under the Controlled Substances Act. And that's still in place today. It kind of has to be renewed every time they are talking about money in Congress, but it's still in effect in its current form. But there are indirect consequences of it being federally legal, notwithstanding that appropriations rider. So some of the areas you'll see that are just definitions, grants, contracts, preemption. Some examples here, Code Swedish Network is a Colorado Supreme Court case that found there's a state law that protects employees from being fired for engaging in conduct that is otherwise lawful. So there was an employee here who was using medical marijuana at night, then tested positive for medical marijuana on a drug test at his employer. They fired him, and he said, I'm protected by this lawful off-duty statute. Colorado Supreme Court said that because medical marijuana use is unlawful federally, even though it's lawful under state law, it doesn't fall within the protection of the statute. Then also there are school programs to prevent illicit drugs, which often get implicated by marijuana use. The Drug-Free Workplace Act, same thing. Disability discrimination claims. So kind of get to reasonable accommodations later, but in this case, they were addressing whether or not medical marijuana use is a reasonable accommodation for the disability. And the court there is an Oregon case. They found that using medical marijuana is not a reasonable accommodation because it's unlawful under federal law. People v. Krause was a case in Colorado where under our state law, it says that if they seize your medical marijuana, you're later acquitted, they must return it to you. The sheriff sued in that case saying, well, that makes us drug distributors, drug dealers to be returning marijuana. And the court kind of agreed with them in that case and said that they don't have to return it to you if it's been seized. Hemp and CBD issues. Hemp, what is hemp? What is CBD? 2014 and 2018 farm bills and hemp-derived CBD products. We'll get into all that, including the risks and concerns here, and the current regulation of future trends for these products. Hemp is defined as cannabis sativa L, any part of such plant with no more than 0.3% delta 9 THC. It's a bit of a simplified definition, but that's basically it. CBD, cannabidiol, is one of at least 113 cannabinoids in cannabis, along with THC. So the 2018 Farm Bill expanded to the 2014 Farm Bill, removed the Department of Justice and DEA oversight of hemp. Marijuana is still within their ambit, but hemp is not. So the Department of Agriculture was given oversight of hemp at the federal level, but FDA oversight remains. So FDA does oversee hemp and hemp-derived products. And so they have taken, notice of the popularity of CBD products that are being made from hemp and being sold across the country. And they take the view that this is not allowed. So they've issued warning letters and guidance about that. They're concerned about a few different things. One is that there are some unsubstantiated claims that they're making, for example, that like this CBD product is going to cure your cancer, for example. There's no science to show that to be the case, so you can't make that claim on a product. Also concerned about inaccurate labels. So there are instances where the product is saying it has a certain amount of CBD and it has far less, or it has a certain amount of THC and has far more. So it's going to give you, more of an intoxicating effect than you realize in that latter example. It also can't be a supplement or a food additive under FDA law. So if it's, first part being if it has the ingredients of a drug, of a illegal drug, it can't be included in a supplement. With CBD specifically, if something is already an active ingredient in an approved pharmaceutical, it's not allowed to be put in a supplement. So as you are probably aware, Epidiolex has been approved, FDA approved CBD-based pharmaceutical for treatment of 2 epilepsy conditions. So because a CBD ingredient has been approved as a pharmaceutical, CBD can't be included in a supplement. So under federal law, CBD can be included in a supplement or food additive. However, the FDA kind of knows that it's going to be difficult to kind of put that genie back in the bottle. And so they're publicly saying they're considering a pathway forward for these products, notwithstanding that normally they couldn't be a supplement that you could sell to people. Risk and some concerns, otherwise, mismatch between label and contents, like I said, CBD levels, THC levels. For one example is 25 milligram CBD oil capsules. That's what it was being labeled as. But it had, between 13 and 19 milligrams of THC and less than 0.1 milligram per gram of CBD. So it had practically no CBD in it and a lot of THC. So if you're expecting to get, a CBD capsule and instead you're getting one with basically none and a lot of THC, you're getting a quite different experience than what you were expecting. So that's a kind of one of the potential situations you might find yourself in if that's the kind of product that you're getting. So there's also concerns with dangerous or unlabeled contents. Some of the examples here are heavy metals, pesticides, bacteria, and synthetic cannabinoids being in these products. And also ingredients, things you'd find in cough syrup being in there. So there's litigation that's kind of percolating in the consumer protection realm over some of these things. So there's been, for example, class actions against Just CBD that claiming it was mislabeled, that there was more CBD than what was in the bottle. So here the label claimed it had 100 milligrams CBD and it tested at 49. They also say that the label is providing false and misleading statements about their testing proficiency, given that mismatch. Another case, this was a hazmat driver who bought a product that was labeled 0% THC CBD oil, but he tested positive for marijuana at his Department of Transportation urinalysis test and was fired. So he's suing that manufacturer for fraudulent inducement and other claims there. So what the trends for these products going forward, states are adding more oversight, packing and labeling requirements, the scannable QR code links to documentation. So you'd have to have a certificate analysis that's tied to that product with a batch number showing you can tie the certificate analysis to that product. And it has test results for cannabinoids, solvents, pesticides, microbials, and heavy metals. And they're also registering producers to make sure we know who's making these things. So then there are new and unregulated products that are percolating. You may have heard of Delta 8 THC, Delta 10 THC, THCV or THCO. There are, as someone who represents a regulator, I have a bit of maybe a biased view of this over what to say about these products at this point in time. So I just thought I would kind of give you a perspective from NORML. NORML is one of the oldest kind of advocacy groups for reformation of medical marijuana or for reforming marijuana laws of all kinds. And, what they say, which I believe to be true, is that most of these products are made from hemp-derived CBD and then synthetically manufactured and sold through unregulated so-called gray markets, like stores, convenience stores, smoke shops, and gas stations. Again, according to NORML, these products have not been reliably tested and have been found to contain many impurities. And NORML therefore strongly advises consumers to obtain Delta 8 THC products only from state-regulated cannabis manufacturers and avoid Delta 10 and THCO products. So buying online, I just have taken this from certain sources out there that try to provide guidance to people who kind of want to buy these things online. Things to look for are comprehensive labels. There are things called a certificate of analysis that should come from a third party, not from the person who's actually making it, with they may call it something else, but a comparable list of test results. And they have a batch number that you can tie to that particular product you're buying that have the results for those things in it, and list THC quantity if you're concerned about having something that's, you don't want to unnecessarily get intoxicated. You want to make sure the THC is listed in there and how much. And it's kind of a bonus if they list that they follow this ISO 17025 standard, which kind of is a lab standard. And then if they follow these particular standards as well for chemists, that again something to look for. And if they're a registered producer, for example, if they're in Colorado and they are someone who is registered to sell products through our regulated markets, then I think you have a little more confidence in what they're doing. Other legal issues. So this is again drawn from some other selected questions, such as the laws protecting people with epilepsy. And again, I'm going to just say this is a little bit outside the scope of my expertise, but I'm just going to give you the best answers that I found, and hopefully, kind of point you in the right direction if you have more questions. But the laws protecting people with epilepsy include the Americans with Disabilities Act, the ADA, the IDEA Act, FMLA, and state laws as well can provide some protection to people with epilepsy. So I just want to start by making sure I get this out here. There are some great resources online, certainly that were helpful to me in preparing for this presentation, and specifically epilepsy.com and the EEOC.gov. They deal with a lot of discrimination claims and issues. And this link specifically, I found to be inordinately helpful in answering some of the employment questions. So this is this was a guidance document that the EEOC put out about epilepsy in the workplace and how the ADA comes into play and provides protections there. So I just wanted to give the full link just because I think that's an excellent document to look at. And then epilepsycolorado.org. ADA, the general idea behind the Americans with Disabilities Act is that employers cannot discriminate on the basis of disability if the person can perform the job's essential functions. Employers must also provide reasonable accommodations that will enable a person with a disability to do the job. So some example reasonable accommodations are breaks to take medication, adjustment to work schedules, leave to seek treatment, private area to rest after having a seizure, a rubber mat or carpet to cushion the fall, a service animal, transportation, permission to work at home, and reassignment to a different position if they can no longer perform that job that they're in. And again, this will all be very fact specific with the nature of the employer and the employee and the job itself. An employer does not have to provide an accommodation if it would cause undue hardship, which means that it would result in significant difficulty or expense to the employer. The employer also does not have to eliminate key functions of a job, tolerate substandard performance, or excuse violations of job-related rules, as long as these standards are being applied to everyone who works there. An employer may also refuse to hire, fire, or restrict job duties for safety reasons if they pose a direct threat. A direct threat is a significant risk of substantial harm to the individual or others that cannot be eliminated or reduced to a reasonable accommodation. So direct threat, the employer must evaluate the individual's present ability to safely perform the job. The employer also must consider the duration of the risk, nature and severity of potential harm, the likelihood the potential harm will occur, and imminence of the potential harm. It must be serious and likely to occur, not just that they think it might happen one day. They also must assess whether a reasonable accommodation will reduce the risk. Reporting, an individual who feels discriminated against on the basis of disability may file a complaint with the EEOC's nearest office. And you can also file complaints with state agencies who regulate state laws that deal with these kinds of things. So Colorado Civil Rights Division or the Wyoming Labor Standards Office. So another question was, what type of attorney specializes in epilepsy-related driving questions? So I think you want someone who deals with administrative or licensing cases. In Colorado, the driver's licenses are handled by the Department of Revenue, and within that, the Division of Motor Vehicles. So an attorney who kind of says that they have handled Department of Revenue / Department of Motor Vehicles hearings, that would be someone who could help with a question about getting a driver's license. If your question is more like the laws about driving with epilepsy, what are my legal risks if I get into an accident, something like that, I think that would be more of a personal injury attorney who could kind of guide you about what are your duties, duty of care, what would be negligent to do in a certain circumstance, that sort of thing. I think personal injury attorney would help you there. Another question was, could I get fired if I miss work for having a seizure? And here are the other facts given. A history of seizures not disclosed prior, has missed 1 week of work due to seizures. So an employee, as I said before, can only exclude an individual from a job for safety reasons if the individual poses a direct threat. And we kind of went through what does that look like earlier. As far as time off, do they have to provide that? Is that a problem that you're taking time off? An employer must consider providing unpaid leave to an employee with a disability as a reasonable accommodation if the employee requires it, and so long as it does not create an undue hardship for the employer. So, if your job provides leave as a policy and you're just taking leave in accordance with your policy, that would be fine. And then the employer should consider providing that unpaid leave if that's a reasonable accommodation for disability. The only backstop is unless that creates an undue hardship for the employer. Reasonable accommodation does not require employer to provide paid leave beyond what it provides as part of its paid leave policy to everyone else. Questions, kind of a two-part question. How do I protect my employment when I have frequent absences due to seizure? And should I disclose epilepsy during a job interview? So under the ADA, so it implies employers with 15 or more employees, they may not ask any health-related questions until after they have offered you the job. Employers must also make reasonable accommodations. So the key thing here is the ability to do the job. If you decide to talk about epilepsy, some items to consider addressing, and I'm taking this verbatim from the Epilepsy Foundation. They say that you should consider talking about your history of controlling epilepsy. And if you drive, mention that. A period of being seizure-free, especially if that's a long time. Lack of convulsive seizures, if that's true. And try to get across how you can perform the job regardless. So some more job offer guidance. This is from the EEOC, that after receiving an offer, an employer may ask further questions designed to assess your ability to perform the job safely. That's different from before they've given the offer of employment. So if they haven't yet given the offer of employment, if it's just an interview, for example, an employer may only ask those who voluntarily disclose they have epilepsy whether they need a reasonable accommodation and what type. Or, for example, if you need an accommodation for the interview itself, if someone needed to bring a service animal to the interview, they may need to disclose that before the job offer comes. And the employer may not withdraw a job offer that it's given if the employee can perform essential job elements without posing a direct threat, which we kind of went through before. So more resources, this is from epilepsy.com, for information, obtaining a referral to an attorney that maybe will provide guidance. They have this Jan Carpenter Epilepsy Legal Defense Fund. There's also a helpline that they provide there. And also they give contact information for the EEOC. So I'll kind of leave that up there for a minute. And that's basically the end of my presentation. I kind of want to leave some time for other questions if people have them that maybe I can either answer or kind of refer to a better source. But that is what I have.
Thank you, Brian.